Good morning. Are you Warren Mills?
Good morning, yes, ma'am.
And Mr. Mills, in cause number 25, DCCR 0082.
This is where things get serious immediately. Assault on a peace officer isn't treated like a normal assault charge. Juries tend to give officers the benefit of the doubt, which means the defendant is already walking uphill before the trial even begins. Right away, the courtroom tension shifts from routine hearing to high-stakes decision time.
You're charged with the second-degree felony offense of assault on a peace officer. That's from November 19th of 2024. What that means is if you go to trial and you're found guilty.
Here's the moment every defense attorney watches closely: the plea offer versus trial gamble. 8 years might sound harsh, but compared to a possible 20-year sentence, prosecutors are basically saying, take certainty now or risk everything later. The real question is, does the defendant fully understand the odds he's betting against?
The range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yeah, I understand that part, yes.
Okay, and I have a plea bargain here on the computer that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case go to trial and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plea.
Yes, ma'am.
You understand all of that?
I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am. Yes, Your Honor, ma'am. I want to reject it and,
Did you catch that hesitation? That pause is huge. Many defendants reject plea deals emotionally, driven by hope, pride, or disbelief, but hesitation often signals doubt creeping in. And in criminal court, hesitation can mean the difference between strategy and regret.
And then I wanted to see, at that point in time, I was, I was incompetent at one point.
Okay.
I was out of my mind, which I have a history of it before.
Okay.
Mental health.
Okay.
But I just wanted to say, I'm docking for everybody that in my mind, my heart, my mind was so I would never hit an officer.
Well, so
This is the situation that I'm in.
The allegations allege alcohol and drugs.
and is there a video?
That's what I was asked. I wanted to.
Hold on.
Oh, yes, ma'am.
I didn't see a video on Discovery. There may be, but I don't.
I have
see
a thumb drive in my file, Your Honor.
Let me do this. So before we move your case to the trial docket, I'm gonna.
This is actually a very strategic move by the judge. Video evidence has become the ultimate truth tester in modern courtrooms. Memories fade, testimony conflicts, but video can instantly change a defendant's willingness to fight or plead. The judge is essentially saying, see the reality before you roll the dice.
Let Mr. Parker have some time to get a copy of that video, and then he can come show it to you. You may not remember everything, but maybe that video will help you understand what happened and then see where we get from there, okay?
Thank you.
If you still want to go to trial after you see the video,
Excuse me, man. Your Honor, I really don't want to go to
well, that's what
It's kind of-
I want you to see everything. I'll give them some time to get that taken care of, and then when you come back, we'll see what you want to do, whether it's a plea or a trial, okay?
Okay, thank you.
All right, you can go back with the
Can I
bailiff.
ask you one more question? Your Honor?
Yes, sir.
In a situation, the probation never come across the table.
That's between your lawyer and the district attorney's attorney. It's whether or not they offer
I
it.
wouldn't. Okay, thank you.
Okay. I'm just going to delete the rejection. If it's we'll do it again later if that's the case. All right. Good morning, sir.
Good morning.
Are you Samuel Jones?
Yes,
And Mr. Jones, in cause number 25, DCCR 0043, you're charged with the second-degree felony offense of burglary of a habitation. That is from November 21st of 2024. Your indictment alleges that you were previously convicted of fraudulent use or possession of identifying information, a second-degree felony, October 20th of 2021. And after that was final, you were convicted of theft of mail, a third-degree felony, December 12th of 2022. What that means is that if you go to trial in this case and you're found guilty, you would be considered a habitual.
And now the stakes explode. Habitual offender laws completely change sentencing math. This isn't just about one crime anymore. Prior convictions stack the deck, turning what might have been decades into a potential life sentence. At this point, every legal decision becomes survival strategy, not just defense.
Offender, which means your minimum punishment if you're found guilty and those prior offenses are true is 25 years in prison up to 99 years or life. Do you understand?
Mm-hmm.
And I need you to answer yes or no, please.
Yes, yes, Your Honor.
Thank you. And I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that and have a jury decide if you're guilty and what your punishment would be if they find you guilty. I just want to make sure you understand what the possible... Okay, I just want to let me finish. I want to make sure you understand your consequences possibly and what your options are. And you want to reject that offer and have both cases. And so you also have, and let me go through this too, just for the record. In cause number 25 DCCR 0232, you're charged with burglary of a building and state jail felony. And that is from January 5th of 2025. I'm assuming those same prior offenses are alleged in that one, which means in that case, if you're found guilty and those priors are true, the range of punishment in that case would be between 2 years and up to 20 years. Do you understand?
Yes.
Okay. And you want to reject that offer and have your case set for trial?
Yes.
All right.
And I'd like to indict everybody who have witness. I'd like to indict everybody who caused this case, signed the case.
Okay. So,
Fingerprints, evidence, and everything. I want everything to be
He's,
everybody
compla-
indicted.
he's complained about some charges that other counties have explained that doesn't have anything to do with here.
so
He wants
here,
everybody here, and I told him everybody will have to be here at trial whenever.
yeah, I mean, whatever the
Okay,
district,
well,
listen,
I let you know I'm 17 code. My code is 774 is my badge number. 477, Barras, Bear County, Patrol Detention.
Okay.
Private detective and everything.
okay.
Private investigator.
All right. So here's what we're going to do before we move any further with this is I'm going to, Mr. Jones, I'm going to have someone talk to you to make sure you're competent to stand trial, get all your history, make sure we're all good before we go to trial.
Yeah.
When they visit with you at the jail, either in person or on the computer, you need to make sure and cooperate with them, and then we can move your case forward, okay?
Yeah,
All right, go back with the bailiff, please. Everybody keeps, y'all just wait, I'm going to get everybody. All right, are you Evan Bowden? Mr. Bowden, you're charged in each of your cases with evading arrest or detention with the use of a vehicle, and what is the announcement?
Your Honor, this is a case where he also has a pending motion to revoke probation out of Chambers County. I've been trying to work something out with him. The prosecutor handling that case is Eric Carcerano, who's currently in Austin for kind of legislative issue right now. I call it.
This is,
I know, but if I plead him out to this, Your Honor, that's automatic revocation over there, and he's going to. I know it doesn't affect his court, but it does.
I mean, you've been on the case since June of last year.
I know.
So here's what I'm going to do. I'm going to reset it 2 weeks.
Oh, that's fine. Should be
And
fine, yeah.
that is the final reset.
Like I said,
Hold on. It's either going to trial or it's going to get taken care of on that day.
So I'm saying the offer that the state's made, we want to accept. We like it. It's great. It's just a matter of I don't want to do something here that's going to automatically send him up there.
Well,
Once I get
I'm sure he hasn't been in Austin this whole time.
No.
When a judge orders a competency evaluation, it's a major pivot in the case. The court isn't deciding guilt yet. It's deciding whether the defendant fully understands reality, the charges, and the consequences. Without competency, the justice system literally cannot move forward. It's one of the rare moments where psychology and law collide head-on.